very warm welcome to you, sir. It's quite a privilege for us to have you with us as the chairperson of the session. May I request you to kindly take over now?
Well, thank you very much for your kind introduction. I hope you can hear me loud and clear. Can you please give me some signal that you can hear me?
Yes, we can clearly hear you, sir.
Excellent. Thank you very much. I'm really delighted on behalf of FIDIC to join you on this particular second day of your program. And thank you very much for giving us the opportunity to share some few words from FIDIC in terms of this subject, which is really about minimizing delay and dispute in infrastructure contract. I am delighted to have three panel speakers, which has already been introduced, which is from Singapore, from United Kingdom, and also from India. I've been given 20 minutes to basically set up, a framework for this particular conversation. And I just want to sort of use this particular opportunity to give you some direction. I hope the slide is moving. Can you confirm if it's moving?
Yes, Chairperson. So the slide is moving, but we would want a clear vision of the slide. Can you just increase the size of the slide?
Right.
Just make it full page.
Working on that. Yeah. Okay. Yeah. Okay. I think it has to be on your side. I've got full screen on my side.
Can we just make it in the slide presentation?
Yes, it says it is a slide presentation. I think you need to make it, or you need to activate it on your side.
If we could slightly check on the slide sharing mode, that just gives us a broader picture.
Right. We are on the slide sharing mode at the moment.
Okay.
Right. Can you see it? Do you have a full picture? Yes, you do. Thank you very much.
We have the picture. We have a
picture.
Thank
you very much. Well, basically, I just want to give you a very quick overview of FIDIC in terms of where we are, and just really going through the process in terms of where FIDIC is at. Some of you probably have some. I mean, is the slide moving? This is pretty embarrassing because mine is not moving. Is the slide moving at the moment?
Right now, we're on the same page.
Yes. Are you on the same page? You got representation of FIDIC at the moment?
It says agenda. And it has procurement and delivery, FIDIC contracts, FIDIC engagement, thinking global.
That is fine.
Yeah,
okay,
now
fine.
It's moving.
Right. Thank you very much. Really, thank you very much. I'm glad that you do have some movement. Basically, FIDIC, have a global footprint, which you can see that I do not intend to spend too much time going through some of those feedback. Bear in mind that I've got 20 minutes. I'm just going to go through some of this slide to give you an overview of where FIDIC is, because it's easy to talk about how do we minimize, delay and disruption in infrastructure, but without understanding the background to FIDIC, it makes it pretty difficult. So from that point of view, I'll just try and go through the process in the sense that, where we are is as an organization, it's always easy to talk about where FIDIC really position, but in the context of political climate, it's important that whatever one does, one needs to be mindful for all the political issues and the challenges that one face. And you only need to look at that screen. It tells you the political landscape that we are going through, whether it is industry changing, there's issue in Ukraine, there is all sort of issue going in different parts of the world. But we are talking about procurement. Procurement obviously does deal with government. But the interesting fact about, the issues in the world, I thought I'd just share this. We know for sure that Africa and India have a lot of issue in terms of, mainland issue that's been set out. For example, we do know the largest pool of, internet connections in Africa is there. We've got the issue about Asia. We have the 7 largest world 10, cities. And the issue about zero in the number is anything that actually resonates with India. The largest pool of engineers are actually available in India. These are the challenges that we face. The global construction output is really important. And one needs to say that there is a big demand for infrastructure. And when you look at the moment, we're actually well below what the world needs. And there's an opportunity for growth. When you look back into the last 12 months, you see some challenges to do with where the growth has been in GDP. And we know that, COVID has actually delayed a lot of, construction work and project in the industry. And we've been active in that area. You may talk about what's the implication of that. Of course, there is going to be issue about dispute and delay, and there will be opportunity in that area of, what does that impact? But going forward, The subject of going green is very much topical at the moment, and this is something that we have to deal with. But then you start looking about where the issue about OECD are coming through and where the opportunities, there's a current challenge of, looking at subsidy required. But overall, if you look at FIDIC engagement, what FIDIC has been trying to do is to address, the need of the G20 through the OECD, and there's a number of priorities and principles which are set up there, and these form the basis of where FIDIC is coming from. Now, you may ask about issue about dispute in construction industry. I thought it was important that we just give you a footprint of those who are using FIDIC contract all over the world, and some of them are activated and are involved with this. ADB, the World Bank, the African Development Bank, all these people are very much involved in the use of FIDIC contract. Look at the infrastructure sector. There's a big challenge post-COVID as how one is going to deliver, and can we deliver to time, to quality, without dispute, and if there's going to be dispute, how do we minimize and mitigate that? These are big challenges that one have to face as we've gone through the COVID and we are coming through the process, and everybody's saying what is going to be changes in landscape. I see issue about going digital, the health and well-being of people, going green, transportation, social contract will be changing, and supply chain and inflow will be different. The issue of globalization is critical, and the use of building will change. So if you come back into the procurement side and look at where the FIDIC fits into it, a lot of what we do really cover client from asset owner to industry, and then you go into the user side, from the people side to the government. All of these are looking into procurement from different, whether it's a single contract or issue about a static partner. And from there, you look at the issue. Where do you need to invest your money? Is it in the operational cost or is it in the capital cost? This is the challenge that every investor look at. But we all know that the procurement landscape is not an easy one to navigate, whether it's federal government or central government, or you're coming from the multilateral development bank. By the time you go from the multilateral development bank to government, to individual state and going into agency, there is a whole host of issues that one needs to look at. The bottom line from this point of view is that FIDIC contract is actually driven from the standpoint of from the conception to the commissioning of contract. And we look at the contract itself, because one thing to say, it's easy to dive into issue about, delay and disruption and claim, but it's important that one needs to understand the suite of contract which is available. So we have professional contract and we have works contract. And I'm sure that I'm speaking to a lot of learning people who understand the difference. Then there's a guide that goes with that, because all of these are very, very critical in the issue of minimizing delay and disruption and claim in the industry. And I tend to look at these, and you need to look at them as a combined suit of what is required to minimize delay and disruption in the construction industry. If we ignore that, we ignore that at our own peril. Looking through why is the FIDIC contract, being well acceptable. It is an international standard. It's been developed over so many years. We have, over 100, professionals involved in the delivery of that. It is an industry standard. We have a good background in how the contract is being used and is well reconstructed by multilateral development bank and the contract award. You look at the framework, because I think the issue is for us, we tend to look at minimizing delay and disruption in contract war, but actually identifying the right contract for the right project in the right environment is critical. Because people tend to focus on purely the dispute resolution process. I actually said the dispute resolution process, come from the dispute avoidance by choosing the right contract for the right project. If we miss that, I'm sure we'll be hearing from our learning party later on. If we miss that particular opportunity to pick the right contract at the right time, then we miss the opportunity of actually minimizing that. When you then look at the contract, whether you put in a JV between the main contractor or the subcontract, the FIDIC contract really covers that. The advantage of also FIDIC contract, we have it translated into so many languages, at least the broad languages of Arabic, Chinese, French, Portuguese, and Spanish. So most of the global languages, we try to embrace that. And again, that makes sure that at least if people are using the contract, they're using the contract in the language and the environment where they're comfortable with. A number of things that FIDIC does, really, from conferences, from award advocacy to membership, these are very critical. Then you start looking at the effectiveness of the contract. Well, we know for sure that the contract, is promote, efficiency in the way it's being looked at. It's accepted by key stakeholders, most of the IFI and the Multilateral Development Bank. Most of them have spoken yesterday or today. They've all been involved in the development of the contract, and they've adopted the contract. It is fair in terms of risk allocation. It reduces corruption. The basic law is actually well covered, both civic law and common law. And then particular conditions allow individual projects to be making bespoke, where you have general condition. Then the adjudication process, which is going to be the big subject for our discussion for the panelists, really is focusing on that. It is built into the contract to avoid dispute as much as possible. Prior to 2017, we have the DAB, but now we talk about the DAAB, which is the dispute avoidance and adjudication process. And I'll come back to that later on. During the COVID, where we expected a lot of big issue, we produced a number of guidance notes to help us to look at the issue of the intervention of the COVID, and that's really helped the industry moving things forward. But why is the FIDIC contract very famous? Well, the general condition is standard. We encourage people not to actually, abuse that standard general condition. The particular conditions allow company, individual, and client to make it bespoke. Then the risk allocation is well understood, is consistent, and very standardization. The tendering process is efficient. Negotiation focus, so everybody knows. The project staff, have an understanding of where to use this. The contract administration itself, is standardized, and the guides are available. And I talked about the difference between the DAB and the DAAB, which really is quite important to make sure at least there is an avoidance element built into the process right from the onset. And to me, I think this is a critical point. And I'll be listening to all the other three speakers later on how they see the migration from DAB to the DAAB, because the avoidance element is equally important. Moving forward in terms of partnership, a lot of the multilateral development bank you can see on the list, they've already adopted the contract, including the World Bank, Asian Development Bank, AIB. They've adopted it, they're using it in different format. And you can actually see that it's not just one book, but the whole process being adopted. When you look through all these banks, they are investing billions and billions of pounds every year in different parts of the world. It's important that we produce enough information. So coming back into avoiding dispute, which is the real issue that we're trying to get into, we have the golden principle, which we've enshrined in the way FIDIC contract is being produced, that is unless there's a conflict with the governing law of the contract, all formal dispute must be referred to Dispute Avoidance and Adjudication Board, or a Dispute Adjudication Board if applicable, for a provisionally binding decision as condition precedent to the arbitration. This is absolutely enshrined in a particular contract, and we do push the issue about dispute avoidance and adjudication. So moving swiftly into the 2017, bearing in mind that I'm, surrounded by eminent lawyers who will be speaking later on, and I will let them pontificate on the good and the bad and what you think about it. But the 2017 edition introduced the DAB concept, and it said in connection with the DAB activity, each party shall cooperate in good faith with the DAB and fulfill its duty and exercise any right or entitlement under the contract of the general condition and the DAB rules and otherwise in the manner necessary to achieve the objective under Rule 1 of the DAB rule. Now, the DAAB is Dispute Avoidance and Adjudication Board. This is something that FIDIC promotes, and this is very important. It talks about a standard board in all three contracts, clearly set out objectives of the DAB, Rule 1, dispute avoidance, preventing disagreement turning into dispute by means of an informal assistance given by the DAB to the party. Now, the golden point here, in previous rule, it is a case of appointing the dispute board when there is a dispute. In the new document under 2017, we encourage, wherever possible, at the onset of the contract, to appoint a DAAB. This means you have a standing DAB. In course of informal assistance, the parties are not bound by the advice given by the DAB, but DAB is not bound by any views or advice given. So the key issue we have is really the provision of 21.3, which is the avoidance of dispute. We talked about it, and actually we are now beginning to see that coming into practice. Now, I'm not going to spend too much time on this particular section, but really what I'm going to do is to expect the three speakers to dwell into this because they're experts in the field. But the issue is that in the DAB concept, we actually promote this as a big issue to make sure at least, when projects are commenced, that you have your adjudicator board appointed at the general point of view. So in terms of the DAB, activity now defined that activity carried out by the DAB in accordance with the contract and general condition, including all informal assistance meetings, and the list goes on, that it must decide to what extent to exercise its power, be and remain independent and impartial. This is absolutely important. That become and remain informed, listen to the parties, be experienced and knowledgeable in the type of work in question. In other words, not anybody can be appointed. You've got to have the right experience. Be experienced in interpretation of construction and engineering contract document. Be fluent in the language of communication and be available to act as the DAB. Now, what is expected from the DAB are clearly set out in the various parts of general condition. And I'll probably move on swiftly to say the key point from us is that we haven't just produced the document as an exercise or as a guide. We actually have the precedent list. And the precedent list, it should be that if there were to be, a situation between the two parties, the contractor and the client, they are unable to agree on who to appoint as the adjudicator or the DAB board, then the matter can be referred to the FIDIC president to appoint. In other words, we do not put ourselves in to be the exclusive appointee of the DAB. We encourage parties, when there is a dispute, to talk to each other to find the right candidate to be the DAB. Only if they fail to agree, can the matter be referred to the FIDIC president for appointment of candidate. And we do have that profile on our website, and it's open. I think the list of the people on the president list is about 90. Up until last year, we had about 45. We've grown that now to about 90 as a result of what we've introduced this last 1 year. So the FIDIC president, it is there. It's available to people. We are gradually working with the world to make sure at least we increase the number of candidates within the FIDIC president. At this point in time, I just want to wrap up before I hand over to individual speaker. My view as FIDIC CEO is very much we represent 102 countries around the world, and we don't make any exception that, what FIDIC does is really, the only solution. We try to put the best standard in for, and I'll be interested to listen to the view from Singapore, from the DRB, and also from Tata to see what their perception on the project is. Let me just open the conversation, and I think we have 3 eminent speakers. My presentation is to be a very high level, fly through the process and let the expert people pontificate on the matter. So I'm going to invite our first, panel speaker. I hope I get it right, Mr. Chon Meng from Singapore, and I'll be delighted if he can take 20 minutes. 20 minutes I've been told, not more than 20 minutes. In my case, I was given 20 minutes, and I've tried to keep that 20 minutes. The proceeding is going to be, I will invite individual to spend 15 to 10 minutes, 20 minutes to present their paper. Then after that, we do the next speaker, and then we do the following speaker. Then we'll have an opportunity for Q&A from the floor, and then we take it from there. So with that in mind, can I invite Mr. Chon Wing Meng from Singapore International Mediation Center? I believe you are the CEO. Is glad to have you on board, and I'll be coming to Singapore to see you, believe it or not, sometime in June. Mr. Wing, the floor is yours. Thank you very much.
Thank you. Thank you, Dr. Nelson.
Mr. Wing Meng is an accredited mediator of the Singapore International Mediation Institute. He graduated with law degree from the National University of Singapore and holds a Master's of Law from University of Hong Kong. He is called to the Singapore Bar and Hong Kong's role of solicitors. With that introduction, thank you so much for joining us, sir. The floor is all yours.
Thank you so much for your kind introduction, and thank you, Dr. Nelson, for the wonderful introduction of FIDIC. Certainly, it is the backbone of many of these construction contracts, and we are very impressed with what FIDIC is doing around the world. First of all, let me thank the organizers, AIMA and World Bank, for inviting me for this eminent session and to have such a great panel with me. I hope to be able to, within the 20 minutes, give a very brief introduction of what we are doing here in Singapore. And with that, let me share my screen. I'm the CEO of SIMC, and here in Singapore, we are focused on dispute resolution, maybe a little differently from perhaps just a pure dispute resolution board, which Dr. Nelson was talking about. So I'll change a little bit, and I'm going to come back to this main topic itself. So in my talk, in the 20 minutes, I'm going to talk about three things: the challenges of infrastructure projects in Asia, resolving infrastructure disputes that we do in SIMC, as well as the case studies. We're going to talk about two very recent case studies that we have. So what are the challenges of infrastructure projects in Asia? Well, if you look at ADB report of 2017, Asia needs more than 1.7 trillion of infrastructure per year. Over the next few years, the infrastructure projects, as Dr. Nelson has pointed out, are very complex, involve multiple parties. Disputes invariably arise. And guess what? When we look at the infrastructure projects, on average, the cost goes up by 80% than budgeted and run 20 months late. So if you look at my, oops, I don't seem to be able to move. Okay. So if you look at that picture that I have there, I was told that this is the Bandra-Worli Sea Link, constructed from 2000 and 2009. The original cost was 6.6 billion rupees to be completed in 5 years. And there was really various public interest litigation. There was a 5-year delay, resulting in costs escalating to 16 billion rupees. I stand corrected if those are not correct, but I think this is really a good way to really understand the context of the problems that we are facing. So those are some of the challenges that we see in infrastructure in Asia, and Dr. Nelson talked about that around the world as well. So what do we do here in SIMC? Well, we approach this in three big buckets. The first one, we are a mediation center, so we talk about mediation. I'll go into that in greater detail. We'll talk about the specialist mediators, the co-mediation, the SIAC and SIMC AMA protocol, and then the very important Singapore Convention on Mediation, which I'm sure many of you would have heard of, and I'm happy to talk a little bit about that as well. That's one big bucket, mediation. The second big bucket is the expert determination, which we have here in SIMC as well. So I'm going to describe that a little bit. And then the third one is on the Singapore Infrastructure Dispute Management Protocol, SIDP, which is really a variation of the dispute board that Dr. Nelson was talking about, and I'll describe that in a little bit more detail. So mediation, what is mediation? I'm not sure how many of you are familiar with it, but unlike arbitration and unlike adjudication and litigation, mediation is where you allow parties to come together to find a resolution for themselves. There are three main factors that distinguish mediation. It is party-centric. The parties will decide for themselves what the solution is. It's very dynamic. It's very creative. They come up with a solution, not the mediator. You have a professional mediator that's an expert on communication that helps the parties to find that solution in a creative and dynamic way, and confidential as well. Very important that the whole discussion is confidential. And the third is the process. We believe that through a structured process of communication and bringing the parties together, we would invariably very often find a solution to the problem. And I will give some statistics around this. So what are the benefits of mediation? Quite clearly, it's efficient. It saves time and cost. Normally, our mediation will be done in 1, 2, or 3 days. It can be set up within 4 weeks. So time is of the essence in many of these construction projects and disputes. So that saves the party's time. It saves the party costs as well. And it also preserves relationship, because a lot of these construction projects, you need to live with your partners, with your contractors in the long term. So the mediated resolution saves that relationship between these parties and allows for flexible and creative solutions. And we have also a very high settlement rate of 70 to 80%. And the third benefit is really enforceability, which I will come to in a minute. So those are the clear benefits of mediation. Next, I would like to talk very briefly about the AMEDA protocol. I know many of you are familiar with arbitration as a way to resolve construction. So here in SIMC, we have what is called the Singapore International Arbitration Center and Singapore International Mediation Center, where we combine the two centers to provide the AMA protocol or the AMEDA protocol. This is a one-stop process where the parties will first go to arbitration, file their case, have the tribunal set up, and instead of going on with the arbitration, the matter will be seamlessly transferred to SIMC for mediation. There's only an 8-week window where a solution has to be found. If a solution is not found, it is either extended. If not, it goes back to arbitration. So this has the beauty of combining the best of the both worlds of arbitration and mediation within one protocol and a seamless way to help parties to resolve their problem. You can see that the advantages are multi-jurisdictional enforcement, access to quality mediators, confidentiality, neutrality, and of course, time and cost savings. If the matter is resolved, it can be enforced under the New York Convention in 160 countries when it is registered back at the arbitration. If it is not resolved as a mediated agreement, it goes back to arbitration. So, as most arbitrators will know, an 8-week window is basically an adjournment in the arbitration process. So I talked earlier about the Singapore Convention. This is an important convention. Dr. Nelson, you're coming by in June. I don't know whether you were here on 7th of August 2019, but we had a big celebration, including the presence of the India's representative that signed the convention on behalf of India. So it was a big celebration, and really the coming together of so many countries, 50 over countries, where we were able to, for the first time, agree on a convention on day one. And that is a marvelous exhibition of really the collaboration around the world. So as of today, you see the world map there. There have been 55 countries that have signed this convention. And what this convention does is that it allows mediated agreement to be enforced in the countries that signed and ratified, very much like the New York Convention. It's a two-step process. First, you sign the convention, and then you have to approve and ratify it, right? So to date, 9 countries out of the 55 have ratified. This convention is enforced. As you can see from the world map, a lot of the countries are here in Asia. And also, really the big economic powers around the world, whether it's the US, China, India, Korea, you name it, are very much involved in ensuring that this convention go ahead and represents the will of the parties and of commerce that mediated agreements should be recognized and enforceable. So let me go to the second bucket. The first was mediation. Very briefly, I talked about it, about the benefits and the enforceability of it. Now, expert mediation, determination is what we do. There are many names for this. Some people call it adjudication. Some people call it expert determination, neutral evaluation. What it does here is that we manages these cases where it is submitted to one or more experts. We will consult with the parties to appoint the experts. It is very neutral, flexible, expeditious, also confidential. And the difference here between the expert determination and mediation is that in mediation, the mediator does not provide a solution or an award or an opinion, whilst here in the expert determination, the expert does. He usually provides a determination that's binding unless parties agrees otherwise. So this is also done in 1, 2, or 3 days, depending on the parties. So this is the second way which we try to resolve these complex disputes. The third is the SIDP, the Singapore International Dispute Management Protocol. I'll just briefly talk about this because I know that Mr. Jeremy Glover will be delving into this in greater detail. So the SIDP was launched by SIMC in 2018. It helps parties to proactively manage differences for large-scale projects, and we are looking at projects of about 500 million or more. It minimizes the risk of time and cost overrun, and we are the appointing body to appoint the dispute board. very much like what Dr. Nelson was saying earlier about the golden rule, where you try to avoid the problem and the dispute before you send it for arbitration. So SIDP, what is it? Three distinct features: proactive dispute prevention, part of the golden rule of FIDIC, and a wide range of dispute resolution. And I think this is where in SIMC we provide something a little different, in that as part of that process, we introduce mediation. So all of our board members in the dispute boards are trained in mediation skills, so that they have an additional skill, additional offering to the parties, in addition to their opinion and determination. So that forms hopefully a wider range of option for the parties to find resolution. And then on our part, we'll provide full professional and administrative support. I'll very quickly go through, without going into the detail. This is really the SDP process. It's very simple. You set the agenda, you have the resolution, and then you find the solution itself. This is a clause that we have. I won't go into it, but this is a dispute management clause that I'll be very happy to share with members here. So very quickly on just introducing SIMC. We are a very young organization. We are 7 years old. We focus on the mediation of cross-border commercial disputes. We have an international panel of 69 mediators across 17 jurisdictions. Our main focus is really case management of disputes, training, whether it's mediation, expert determination, and promotion of mediation and thought leadership. We are based here in Maxwell Chambers in Singapore, and Dr. Nelson, when you're here, we'll be very happy to host you. This is just some notable members of our mediator panel. As you can see, we have representatives from India, from South Korea, Japan, USA, etc. And this is just a group of, a sample of the 69 that I talk about. You will see that our overseas users are from all over the world with a large representation from India and China. To date, we have more than 200 cases, dispute value of 6.2 billion. So every dispute is very sizable. It's about $30 million on average. And our settlement rate is 70 to 80%, which we are very, very proud of, because it represents the confidence of the parties going into the mediation, that they have a level of confidence that the matter will be resolved. So this is just a photograph of mediation in the age of COVID that Dr. Nelson also mentioned. As you can see, everybody is masked up. So this is what we call a hybrid mediation, where people are both in person, the parties are in person, and also online. So everything is seamless, both in a joint session and in what we call a private session, which we will meet parties on their own. So just two very quick case studies, and I'll finish up in the next 3 minutes or so. And I think you will find this interesting. The first one is really a case that I heard myself, so I can provide some level of detail without providing any information on the parties, but it's a dispute of a construction dispute where a French architect was suing a developer here in Southeast Asia. I won't mention a country, but through the process of the one-day mediation that we had, we found that really it is really more than just a question of dollars and cents, but also diving into the interest of the party. In this case, the French party was very keen to ensure that they are recognized for that project, because that project went on to win multiple awards in competition. So one of the ways in which we could find a resolution that's not just dollars and cents is to address the deeper interest of the parties, which is the reputational interest of the parties in this case, and help them to find a resolution. At the end of that one-day mediation, I remember one party, at the start of the mediation, they won't even talk to each other. They won't even want to be in the same room, as you can imagine, because the dispute's been going on. But at the end of the day, I heard one of the parties said to the architect, say, "I will see you next week in so-and-so city. We welcome you into this project." It seems the architect, having designed that project, has not even stepped into that his own design. So you can imagine the kind of emotions that was involved at the end of the day when this matter was happily resolved. The second one that I have very quickly is an energy dispute between European and Asian parties. I highlight this because it just demonstrates the complex nature of mediation. There were 5 parties across 5 different jurisdictions and time zones, and we were able to have this mediation over 3 days, really and capturing the kind of disputes that you see in energy. And again, this shows that even very complex multi-million dollar, in this case, tens of millions of dollars project can be mediated and can be mediated successfully. Again, the parties provide me very strong confidence that it was a very useful process that they went through. And with that, I would like to just close and thank everyone for the time. And I believe I just made it to 20 minutes and hand the time back to Dr. Nelson. Thank you.
Thank you very much, Mr. Meg. That was a very good presentation. Now I'm going to come back into that later on. So can I go back to our MC to introduce Mr. Jeremy Glover? Back to you.
Thank you so much, sir. May I request you to kindly make your presentation, sir? Over to you.
Thank you very much. And thank you to the AIMA and the World Bank on behalf of the Dispute Resolution Board Foundation for inviting us to be part of this important discussion today. Just trying to share my slides with you. Hopefully you can see the slides on the screen. So yes.
Yes, we can.
You can? Perfect.
Yes.
Perfect. Good. So, thank you for the very kindly generous invitation. And I wanted to discuss with you today the value of dispute boards, not really or not just in relation to resolving disputes, but as Nelson highlighted earlier, the value of dispute avoidance. I think really sort of dispute avoidance is something that I very much want to focus on. So just briefly looking at what actually a dispute board is, this is a quote taken from the ICC dispute board rules, and it's a standing body set up upon signature right at the beginning, at the outset of a project. You know, infrastructure projects, they could last 3, 4, 5 years. So you have a body there right at the outset. And the idea is to help the parties overcome disagreements or disputes, but primarily to avoid any disputes that may arise during the implementation of a contract. And Nelson's talk was, he was talking about finding the right contract. And as we'll see from having a brief look at the history of the dispute board, that FIDIC has adopted the dispute board in many forms very early on. And also the World Bank too. Has been right at the forefront of promoting the value of dispute boards and the use of dispute boards and the value of dispute avoidance. But as you'll see, dispute boards have been around almost 50 years now, starting in the US, but they're now very much a global phenomenon. FIDIC's used 120, 160 countries, and FIDIC adopts the dispute board or the dispute avoidance board, which came into place in 2017. So why do we use dispute boards? Well, it might be simply that the contract says that you have to. It might be because the contract says that the use of dispute boards is a precondition to arbitration. But the most important reason why we might want to use dispute boards is that they might work. They might help you avoid disputes and so avoid arbitration. The quote on the screen is from an English decision. Mr. Justice Aikenhead, who's now retired from the bench, is actually a prominent dispute board practitioner and member of many dispute boards himself. And there he talks about they're quite common. And what the idea is, they keep a weather eye on the project. They can make recommendations to the parties with a view to nipping in the bud issues before they actually become claims, before they become controversial, before they actually become disputes. So what you need to think about is how do they actually do that? Well, you have your dispute boards appointed at the beginning of the project. They're normally eminent professionals. They might be a combination of engineers, construction lawyers, people who specialize in quantum, people who get construction, people who understand how projects work. So what they're independent, and they can rationalize behavior. They're people as a sounding board, they're people you can talk to, there are people you can raise issues with, and they're sort of there to guide the project. I'm certainly not talking about a sort of group of 3 lawyers. I don't think that would work at all. But it's got to be a mix of a sound mix of professionals. So you get people that actually understand how construction actually works. I think FIDIC said this in the guide to their gold book, which is used for projects which are designed and built and then operated by the contractor. Prevention is better than cure. The dispute board is there to provide informal assistance to the parties at any time in an attempt to resolve any disagreement. So we're not necessarily talking about making a formal decision. They can assist. Informal assistance can take place in many different forms. It could be providing an informal opinion. It could be entering into some form of mediation process. The key to informal assistance is that both parties ask for it. And both parties are more likely to ask for it if they trust and understand what the dispute board is all about. Now, I'm talking about dispute boards. There are many different types of dispute board. You have a dispute review board, which makes non-binding recommendations. FIDIC has the dispute avoidance adjudication board, which makes binding decisions, but the primary focus of the DAAB is dispute avoidance. You can combine your board. You can do both. You can call you have a conflicts avoidance panel, dispute resolution expert determination, as my sort of colleague has said just now. But the important things are you want your dispute board members to be impartial. Ideally, you want them to be subject to the approval of both parties. The idea is the fees and expenses of dispute board members are shared equally by the parties. As I've said, ideally the board is organised before work begins. And the idea is that the DB then keeps abreast of what's going on the project, keeps abreast of developments. This can be done through the provision of documentation, perhaps the regular site monthly reports, progress reports, and also by making regular site visits. And by regular, I mean, say, every 3 or 4 months. So they actually get to know what's going on, and they get to know the people and personalities who are involved in the project. And the concept of dispute boards, it's 2. Dispute avoidance. Trying to avoid the disputes, avoid the need for dispute resolution. But when it comes to dispute resolution, we're talking about resolving the times in real time, as and when they arise, not storing everything up until the end of the project. So we talked about the site visit. Periodic meetings gives the dispute board an opportunity to review the status of outstanding issues. The purpose of the site visit, to see the site, become acquainted with the progress of the works, maybe take a view on any actual potential problems or claims that they may see happening, understand the methodology, understand the site conditions. Often on infrastructure projects, the issues arise as the project goes along. Different conditions are encountered. And I think one of the most important points of the site visit is to meet the key people. So, benefits of the site visit. Now, funnily enough, just knowing that someone or a group of 3 people are going to come and visit your site in 3 or 4 weeks' time might actually encourage people to agree any issues before the dispute board turns up. That's just human nature, that's human behaviour. But also knowing that these people are going to come along, it makes the parties concentrate. What's actually really important on my project? Progress, quality, cash flow. What are the issues which are causing disputes? So by the mere knowing that people are coming along, encourages people to focus on what actually matters. And the dispute board, if they're skilled, professional, know what they're doing, they're going to promote discussion of concern. And they're going to encourage communication. So a lot of talk, rightly, in this session about dispute avoidance. What's the best way to avoid disputes? It's to talk to each other. Communication is such an important part of dispute avoidance. And one of the problems of today is that we communicate by text, we communicate by email. We don't do the old-fashioned, picking up a phone, pressing a few buttons, actually physically talking to people. A particular value of a dispute board is it encourages people to communicate. And in global projects, the virtual world, because of COVID that we now live in, you can talk to each other in many different ways. But we're all communicating today through screens, and that's far better to be actually talking to each other through screens than it is to be sort of sending each other a few messages. So that's sort of key issue in relation to dispute avoidance: communication. And then we've got this concept with FIDIC introduced, the informal assistance. It's not producing a formal decision. It's very much, it's on a way to mediation. It can be mediation if the parties want. But what it is, it's a consensual process. The parties must agree. They must jointly refer a matter in writing, so there's no doubt about what's going on. The parties must be present at discussion, but they can agree otherwise to make it a more formal mediation process. And they ask the DB to say, well, what do you think? The informal assistance could be by way of a note. It could be by way of the dispute board giving a conclusion at a meeting. Everyone goes to the site, everyone knows there's a particular issue on site they're concerned about. There's a discussion at a meeting, perhaps parties present their case, and then they can say to the dispute board, well, look, what do you think? And then the dispute board, because they're skilled professionals, can actually say, well, this is what we think. Now that has value because the parties get an indication of what independent people think the answer is. It also might have a value because it's not a formal decision. Sometimes the fact you have a sort of decision written in blood, as it were, means that people get, well, this is what the answer is. And it becomes much more difficult to actually achieve a full and final or lasting agreement and settlement of an issue. So how do you practice dispute avoidance? Well, I've said, and there it is at the top of the slide, encourage communication. Choose your dispute board carefully, make sure they have the experience to know what's going on. And that's why the FIDIC list is a good list, and that's why FIDIC very open and transparent about the various skills and experience of the members of their list. The DB there, it monitors the project, but it doesn't sit back. It can take the initiative if needed. It keeps itself informed. It knows what's going on. The informal advice option is a really useful one, and it helps the parties talk to each other. And the idea is that it encourages disagreements to be settled amicably. And just a brief word about the flexibility of the dispute board. The World Bank has last year introduced a particular brand new initiative, something new and different for dispute boards to use. There's a change to their conditions of particular application. They expanded the role of the dispute board on selected contracts where they think there's a high risk, of sexual exploitation or sexual exploitation abuse or sexual harassment. And I mention this just to sort of, because it does highlight the flexibility of the dispute board role. It also highlights the concern and the World Bank, who worked together with FIDIC, DAB practitioners to address particular concerns with infrastructure projects. So it's new, it's a new development. High-risk projects at the moment, these projects are primarily in Africa, but we don't know. But it's just there as a new thing and something to sort of be aware of. But dispute boards generally, they are used a lot. Lots of big projects across the world: Channel Tunnel, Olympic Games, Panama Canal, Australia, the States, Asia, the National Roads Development in the Philippines, Istanbul, Ecuador, and across Africa. They're not just used for construction either. IT projects, process plants, shipbuilding, telecommunications, I'm even told film and TV production. And why are they used? Well, are they effective? The DRBF has carried out research which suggests that yes, the DRBs are effective. In 2018, they tracked, in the period leading up to 2018, tracked a number of projects with a value of over $25 billion US. These were infrastructure projects, mainly roads and bridges. About 40%, 47% of the projects were roads and bridges, 14% were power generation, 10% were reticulation to do with the provision of water networks. And the question that was being asked is, well, are dispute boards effective? Now, I can see that that's quite a general question as to whether, are the dispute boards effective or not? But drilling into that, were the dispute boards using dispute avoidance? And yes, almost 60% of the dispute boards were. And remember, this is in 2018, only just after the introduction by FIDIC of the new 2017 form of contract with the Dispute Adjudication Avoidance Board. And one of the things that FIDIC has done is enter into a number of agreements with the World Bank and the other development banks for the use of the 2017 form, for the encouragement of the Dispute Avoidance Board. Were parties satisfied with the dispute avoidance being operated, processes being operated by the dispute board? And overwhelmingly, they were. And how can you show, I'm satisfied? Well, that's good. That's good. And that tends to mean that disputes are being avoided. But the sort of proof is in the pudding, in the proverbial pudding, as it were. There were a number of decisions, 500 decisions being made by these dispute boards. Only 32 went to arbitration. It's a very, very small percentage. And even less were actually overturned, or in part or in whole, in the arbitration process. Now, dispute boards resolve real-time dispute avoidance, real-time dispute resolution, avoiding disputes, avoiding having to go to arbitration, which, as we all know, unfortunately, sometimes, despite the best efforts of the arbitration bodies, the arbitrations can last as long as the construction projects themselves. And that's of no use or benefit to everyone. But with the dispute board's understanding and being part of the process, dispute board decisions are accepted. So they're successful. And the costs, 0.06 to 0.3% of the final construction contract amount. Records show that the standing DB appointed at the commencement of the contract assists in the avoidance of disputes. And the other reason that dispute boards are effective is because they're being adopted by contracts globally. And I just wanted to end by, if you want to know a little bit more about how dispute boards work, you can download the DRBF manual. There's a link there to the website, and there's also a QR code on the slides. And just finally, if you want to know more about dispute boards in India, I just want to mention we have a representative in India, Mr. Vijay Nadkar, and very pleased that he will be able to join us in the Q&A session, which will be coming up shortly. So thank you very much. That's all I have to say about dispute boards and dispute avoidance.
Thank you very much, Jeremy. Thank you very much for your presentation. That's quite timely. I'm going to hand over to our MC to introduce the last speaker, which is Mr. Venkatrama. So do I have the last speaker online, ready to go?
Thank you so much, Chairperson of the session. Thank you so much for that brief introduction. May we invite you, sir, to give the presentation.
Thank you. Thank you for the introduction. And also thank you for the organizers for inviting me to this session. I'll be sharing the screen. Just let me know if my screen is visible. Is my screen visible?
No, we're still waiting to have it visible, or is it just me?
No, we can't see the presentation as yet.
We can't present.
Yeah.
Just give me a minute.
Sure.
Yeah, can you see my screen, please, now?
So we can see the slide.
There's no voice coming.
Yes, we can see the slide.
Yes, thank you. So basically, the infrastructure projects typically involve high cost and are technically complex. They have a long gestation period and also involves multiple parties engaged in different scope of work. So this typically leads to delays and cost overruns, which are a common issue in infrastructure projects. I have two examples here. I think one of the examples Mr. V. Meng has already referred to is an iconic project of Mumbai, so Bandra Worli Sea Link. You can see the huge cost and time overrun that is there in this case. You know, it is originally scheduled to be completed in 2004. It actually got completed in 2010. And another classic example, I think everybody knows about this, is the Sydney Opera House. There's a huge time and cost overrun to this project. And there are various reasons for these delays that occurred in this project. Next slide, please. So I now take you through the macro level reasons for the infrastructure contract delays and disputes. The complexity of the projects coupled with long gestation periods and life cycle of the project, changes in political, economic, and regulatory environment, delays in giving possession of encumbrance-free land. This is very important and which is very specific to the Indian scenario, and more specifically to the linear projects, transportation projects like roads and railways, different site conditions and geological surprises, cash flow constraints, poor contract administration and non-conformity of contractual obligations, execution delays, and delays in settlement of claims and disputes. Can we go to the next slide, please? Construction delays. Are you in the next slide, please? Yeah. Construction delays can be defined as late completion or late start of activities to the baseline schedule, directly affecting the specified costs. Next slide. There are various types of delays. You know, they are based on the origin, whether they're compensable or not compensable, and depending on the timing. The origin of is based on who has caused the delay, like whether it's the owner caused delay or the contractor caused delay, or whether it occurred because of the third party. Compensable, again, if it's an excusable delay, they are compensable, and not, there are compensable delays and non-compensable delays. And here it all depends upon how the contract is structured. And then the timing, depending on the nature, whether it is a critical event or a non-critical event. Can we move to the next slide, please? So I have listed out the causes of delay, and I have stated to whom this delay is attributable to and what is the mitigation plan. As I told earlier, the delay in handing over right of way and site is typical to the Indian scenario. More often, we have seen that the landowners are compensated by the project proponent and the employer, whereas the tenants who are at site are reluctant to vacate the land. And this is more prevalent and more relevant to the linear projects, which are transportation and road projects. And the government of India have recently taken some steps. They have taken some steps where they said that unless certain percentage of land is available, then only the projects can be awarded. And they have recently said 80% of the land for public-private partnership projects and 90% for the EPC projects. Unless it is available and it's in possession, the project cannot commence. The next cause of delay, which we see, is that the delay in progress payments and clearance of bills. Of course, this actually affects the cash flow to the contractor and thereby delays the project. The government of India has taken certain steps to clear the contractor's bills within certain timelines that is prescribed. What is important here is we have also seen clauses where the contract clearly prohibits grant of interest to the contractor, even if there's a delay in payment. So this is a classic example of an imbalanced contract. What we see is, if at all a matter goes to the arbitration, the arbitrators are the creators of the contract. They have to be within the four corners of the contract. And we have seen cases, in spite of a proven delay in payment by the employers, the arbitrators are unable to award interest on the claim amount because of this specific clause. Of course, then the remedy to the contractor lies elsewhere else. Can we go to the next slide, please? So this is delay in approving designs by vendors. This is a common cause, and this can be mitigated if there's a competent, experienced, and independent engineers at the project. This is very unique to certain projects. Of course, for EPC project, the engineering is within the scope of the contractor, but even then we have seen certain approvals and all are delayed. Can we move to the next slide, please? Change orders by owners during or after the original contract period. Contractors cannot typically refuse to do the change orders, work for the change orders, but the disputes typically arise due to disagreement on the price to be paid or the time to be granted for this additional work. And these disputes can be avoided with a sound contract administration. And the implications of this on the contractor, if the contract so provides, is extension of time and delay costs. Yeah, differing site conditions and geological surprises. I think there's a spelling error there. Typically, the contractor prices is based on the tender data, and if there are any subsequent changes to them, and there are variations in the site data provided in the tender conditions, this will have a huge impact on the execution of the project. I think the only way, the best way to mitigate this is to the tender documents provide the accurate and the recent investigation data instead of relying upon the old data that is there. And also another way to mitigate this would be to provide enough time and opportunities for the bidding parties to have a first-hand information about the site conditions. Can we move to the next slide, please? Yeah, force majeure clause. This is a very important clause. In recent times, we have had a close reading of this clause more than any other clause because of the lockdown situation and the COVID virus disruption. And we actually started looking at the rights and obligations of the parties arising out of force majeure situation only for the last 2 years. Otherwise, it was this template clause, and this clause has a lot of significance is attached to this clause. Of course, the rights and obligations of the parties depend mostly on what the contract specifically talks about. In a COVID-like situation, which is a worldwide phenomena, it is not a localized FM situation. The way the contract has to be read and the way the obligations of the parties have to be cast upon, we are still waiting for some judicial opinions on that. But of course, there are already varied opinions, and most of the judicial pronouncements are in favor of reading the clause strictly. Can we go to the next slide, please? This is the seventh reason, cause for delay. This is changes in government regulations and laws. It's important for the contractor to follow the norms and the rules, the recent government regulations. This will have a huge bearing on cost and time on the contractor. But it's also very important that the contractor monitors the changes of government regulations and laws constantly and follows them. Next slide, please. Delay in obtaining permits and approvals from the authorities. Typically, the owner is responsible for getting the permits and approvals from the authority, but coordination and licensing for getting these approvals and permits are cast upon the contractor. This is again a very classic case of slightly imbalanced contract. What happens is there's a lot of confusion with respect to who has to follow up for these approvals and permits from the statutory authorities. And typically, we have seen that the government authorities would prefer to license and coordinate with the employer, who's again a government agency, rather than a contractor to the government agency. Next slide, please. This is, as I told you earlier, the complex infrastructure projects involve multiple parties who do multiple. The scope of work is quite varied, and the delays that occur because of lack of coordination with other contractors appointed by the owner. And this is something which can be mitigated by regular weekly and monthly review meetings and with the sound contract administration. Can we go to the next slide, please? Yeah, the effect of social and cultural factors. I think this is an external factor, but it's a very important factor. Whenever the project proponent comes up with a project, it is, I'm not saying only, but the focus is primarily on the financial viability of the project, and very little emphasis on environmental and social costs and impact on the local population, and the socio-economic conditions, local conditions are not really given priority. This actually leads to, after the project is announced and after the contract has been awarded, as and when the work starts there, we have seen some opposition to these projects and the projects get delayed. And this also leads to some kind of a local unrest and socio-political causes. Next slide, please. Okay, I think a lot has been, Dr. Nelson has pointed out with regard to the dispute avoidance mechanism that is contemplated in the new FIDIC formats. That's a very welcome change, because we all know that as we move up the dispute resolution steps, whether we move to the arbitration and then subsequently to the enforcement of arbitration and applications filed challenging the award, the time is there, and the huge cost overrun is also there. So I think the dispute should be resolved at the lowest possible level, and a lot of focus has been made by the other speakers in this group on that. The next, please. I think there are some very good steps that have been taken by the Government of India, and there are also legislative changes that occurred. Most important is with regard to the amendments that came to the Arbitration and Conciliation Act in 2015 and 2019. The most important thing is that there are strict timelines that are defined for the arbitration proceedings as well as for the subsequent challenges to the award. The new law that came up in 2015 clearly says that statement of claim and statement of defense has to be filed within a period of 6 months from the date of receipt of the notice by the arbitrators. So there are strict timelines for completion of pleadings. And by insertion of a new provision with respect to the timelines for the arbitration proceedings itself, there is an insertion by Section 29A of the Arbitration Act, which clearly stipulates that the arbitration has to be completed within 12 months from the date of completion of pleadings. And that is a very, very important step, because there are clear defined timelines for completion of the pleadings as well as for the arbitration. And even for the subsequent appeals that are there, it provides for, it actually provides for timelines for deciding the appeals. And also a very important step is that unless the court grants stay, the award still remains an executable decree as per the Arbitration Act. So there are timelines for application under Section 34, which has to be disposed of within a year. That's a very welcome legislative amendment that has come up. And there are also Commercial Courts Act, where the value of the litigation is about certain threshold level. They go to the commercial courts, and where the commercial courts decide the disputes within the specified timelines. Can we go to the next slide, please? There are other government initiatives. I think one of the most important government initiative, which is not there in this slide and which occurred to me because it was mentioned by the previous speakers, is with regard to the mediation. Indian government, India has tabled the mediation bill in sometime in December 2021. And I think it is, consequent to the India being a signatory to the Singapore Convention that the earlier speaker just spoke about. I think that is one of the very important. What happens with this is that the mediation will be an enforceable, the mediation award will be enforceable. But we are yet to see how this bill pans out and how this will be implemented in our country. And there are other government initiatives that were taken up, which actually resolves the dispute and increases the cash flow for the contractor. The NITI Aayog has come up with a circular, which is basically a cabinet committee on economic affairs, which decided that whenever an arbitration award is challenged, 75% of the such award amount has to be paid to the contractor on furnishing of bank guarantee. And there are further relaxation of the rules. Earlier, they also asked us to provide the bank guarantee amount for the interest as well. That has been relaxed. That's all from me, Dr. Nelson. It's all to you. And thank you so much for giving me this opportunity.
Thank you very much, Ramana. I think we've got good time now to cover Q&A. So can I just get the proceeding right? Rao, do we want to take the Q&A before we summarize, or do you want me to summarize before we take the Q&A? Can you guide, please?
Yes, if you could just summarize the session first, and then we could move to the Q&A. And we would prefer to take the physical questions and then go towards the virtual questions.
Thank you very much. Thank you very much. Thank you, Ramo. Well, let me just put it this way. We've had 3 eminent speakers who are experts in the field. And I just try and go through the presentation as quickly as I can. I think in my case, I probably, gave you a perspective of FIDIC in terms of where FIDIC is coming from, the genesis of the FIDIC, and where FIDIC is at in terms of engagement with Multilateral Development Bank. And that particular summarized, that we've got 8 Multilateral Development Bank who've already adopted the FIDIC condition of contract. And really summarizing that really it provides for the DAB and also goes on to talk about the DAAB. And I tend to finish that up by basically saying that FIDIC is there to act in independent, unbiased position should the party fail to appoint jointly, mutually, the party for them to be, the dispute adjudication board. And basically say here a list of possibly 90 people who are on the precedent list, and they are covered around the world, and to the extent that they may be approached either through the FIDIC president direct or coming straight online. So that was the summation of where FIDIC is at. I think my presentation was followed by, my eminent person, Mr. Meng from Singapore, who really touched about, slight different approach, not necessarily totally different, but actually, complementary, if I can use that phrase. And I think in his approach, he talks about the 3 types of means of dealing with dispute. It talks about mediation, and he talks about the expert determination, and then talk about the SIDP approach. But wrapping that up was the idea of the, we've got so many countries that have signed up to the system that is operating in Singapore, which is actually quite interesting to understand that, so many countries have actually signed up. Out of 55, you got 9 of them that's actually signed up, which are operational. And believe it or not, Mr. Meng, I am aware of what, your organization do. And in fact, in the process of signing an agreement with the AIIB, they insisted that, any, dispute or issue that may arise between them will not be under European law or, under Swiss law. It has to be under your system, which we are gladly delighted to take that on board.
Thank you.
But I think if I can sort of point that into your presentation, you talk about the benefit of mediation, which is, the process itself, and then the preference and the confidentiality that goes with it, and really about communication. As a qualified mediator, I know exactly where you're coming from. And a practitioner, then talk about expert, determination, which really looked at, some people call it adjudication. And in UK, you are binding under the 28 days rule. As a qualified adjudicator, again, I understand that process that you need to go through. So which is quite interesting. But what I also find interesting was your arbitration, mediation, and arbitration process, which is quite unique. And that brings to the whole lot into the context of, you could start the arbitration, but at least segue into mediation, see whether you can resolve the issue. And should that fail, you can go back into the arbitration. And I think it's a cost-effective means of, avoiding prolongation in the arbitration, because one of the biggest, complaint in the ADR sometimes is to say the arbitration is equally as expensive as litigation, and therefore, if you can segue into the mediation side, you may be able to resolve it. And I think you're quite right to some extent, because people go into dispute being defensive. And sometimes if you can unlock it and break the relationship, and understanding the point you raised that people want to work with each other, They don't want to fight each other. They want to be friends. They want to work on subsequent projects. So the arbitration, mediation, arbitration approach seems to be something that I think is highly recommended and should be adopted going forward. So, I mean, I take that point. And I think, the issue about the Singapore infrastructure dispute issue, which is about SIDP on major projects, is quite interesting. We went across to talk about Jeremy Glover, a very good friend of mine. Jeremy and I come a long way. We are both Brits to some extent, so I need to declare my potential conflict of interest here. So I'm not going to be biased in that. And again, we've been working very closely with Jeremy in looking at, how we train people to become an adjudicator. Jeremy's focus is really, he said, his focus is about avoidance. Avoidance. That was the key point. He said it's about avoidance, and it goes into definition of the ICC into a dispute, rule. And he started by saying, look, the whole idea of the DRB or DAAB really starts from 1975. It's been well established, and the process is now well known to the extent that the bank have actually adopted that. I think the word he uses is said about nipping it in the bud at the earliest possible time. And really, this is why we need to look at the whole essence of it. Now, he talks about the DAB, some of the attributes and the characteristic of what that means, about looking people who have knowledge of the industry, experts, and avoid conflict in as much as possible. It then talks about the issue about it is important that communication is ingrained in the process, because sometimes people are locked up in their own world and they fail to move across into the whole process. So he stressed the importance of communication in the process. Then he went through the whole process about, what is the benefit of the DRB. And I think that came across loud and clear. What I also find very interesting was the statistics of the success rate that he talks about. And I think the statistics may seem a bit, surprising high, but actually people don't want to fight each other in the sense that the whole industry want to be friendly to each other, and the supply chain want to work on the next project. So it's intrinsic in both parties to make sure we find a resolution. Now, one point that I picked up was the statistics about the cost of, DRB, and I thought that's quite interesting. If you look at insurance policy, and you're actually paying, less than 0.3% of the cost of the construction work for avoidance, actually means a lot. Because when you look at some fantastic projects around the world where you've had cost escalation due to delay or all sorts of issue, and we know that it doesn't matter how good you may be in the industry, you don't know fully what is under the ground. I know that as an engineer, I know that. And it doesn't matter how good your geotechnical investigation, your geological investigation, there is no way you can do your pie and be able to determine every single meter of the land to make sure you cover. There will be unforeseen ground situation, there will be delay, there will be issues that come up, and ultimately the idea of having people who are experienced in the industry, people can help to monitor the program, to review and to facilitate in the process. I think that is absolutely very, very critical. And I think, Jeremy then closed out by saying it isn't just about, dispute resolution board, but the World Bank has actually put the role of the DAB to the next level, where you're actually now putting issue about sexual exploitation or abuse being put into that responsibility. That has not been tested yet. Jeremy, you and I know that, but it's interesting that the bank are thinking along that line. And the mere fact that the bank has approached, FIDIC and asking us to be training people now in anticipation, it shows to me the direction of the travel of the Multilateral Development Bank. As we all know, when the bank move along that area, the bank have to do that before, the rest of the Multilateral Development Bank will move along that line. My view on then, it means training people now to become an adjudicator. They need to take that on board and bear that in mind. Then we have our friend from Tata Project. I mean, how can I summarize that? Eloquently deliver back into the traditional world. One thing again I need to share with you, I am an engineer, I am managing FIDIC, but actually I spent my early part of career in the contracting world. And I do understand exactly where you're coming from, because you break it down into really the definition and what is the source of claim. I think that to me was the point. Yes, it's an issue that the cost of claim is high, projects are complex and there are different issues and challenges that projects face. Depending on the complexity, you will have challenges that are facing. But actually, when you look at the point you raised about what is the origin, and okay, what is the compensable issue that needs to look at? And then what are the delay mitigation strategy? I think you eloquently cover that to go down into your 9 or 10 points of the source of claim and how to mitigate it. And I welcome those particular, summary that you pick up. Again, I think as an engineer, I can live with that we don't always get it word perfect from the beginning, and there's always scope for change. But one of the points you raised, which is important, which is the issue about force majeure. We've all been going through COVID, and we've seen different legislation, being applied in different parts of the world. We knew the time series of the COVID affect different parts of the world at different time. And therefore, the interpretation of contract and clauses are varying, and the jurisdiction is also important. And when you have an intervention of that nature, it's very important that, the party needs to be very mindful of that. For example, if you are stopped from working on site, it's not because you don't want to work, it's because the law stopped you. What does that mean? And what does the contract say? And how do you deal with that? What we find that in FIDIC when we're dealing with COVID was it was absolutely imperative that both parties are speaking, which come back to what Jeremy was saying. Communication is very important. To understand the issue, I think because, we call it, in my days of claim expert, we used to call it the cause and effect. What is the causation? What is the consequential impact, and what is the effect? And then you've got a claim. And then when you have a claim, if it's reasonable claim, then the party should be open to discuss it and deal with it and move forward. There are some issues that we have to deal with. But let me just wrap it up by saying we've had 3 fantastic speakers, all from different angles. I think my bit was really to unpack where FIDIC is coming from, what FIDIC is doing, and the standard we're setting across. I think Mr. Meg looked at, the system being operated in Singapore, and I find that very useful, and I will be coming to Singapore, and I'll be coming to see you. Jeremy looked at, how the process works, the benefit of it, and then we went through the process of, the granular bit of understanding what causes it, what is the implication, and how do we address that? So we have 3 fantastic speakers, plus myself. I think that's giving us a ground to move forward. I hope I've done a good justice in summarizing what you guys have already been talking about your last 60 minutes. So we're going to pick up the question from the floor. With your permission, Raul, can I go on and pick up question from the floor? Or do you want to sort of, say a few words before we move into that? Raul?